Hi, my name is Paul Taylor, and this is part 3 of raising a charter question or constitutional question before an administrative board, tribunal, or a commission within Ontario. As I said before, this isn't legal advice, and you should seek legal advice whenever you're taking any legal action. And more importantly, this really is only impacting Ontario, but it gives you an idea of what to do in your home province. Now, for example, in Alberta or maybe other provinces, you can't bring a constitutional question to the board or tribunal, but you can do it to the courts. So you would have to do some legal research in your home province to find out exactly. I now want to talk about Section 15 of the Charter and the cases that I reviewed or that are reviewed specifically involving workers' compensation. As you can see, there's quite a few, well, there is actually quite a few that have challenged the historic trade-off, challenged different issues, and I'll just quickly review them with you because you might come across an issue and say, well, you know what, I think it's a Section 15 challenge, and if it's already been done, unless you have a very creative argument, it's not that it's pointless. I'm just saying you're going to have a harder time if that issue's already been decided. But that's not to say not to try it. You can, you just have to work harder, even harder at it to win if you intend on winning. The first is Recanto v. O'Brien, and that was the case that dealt with the court found that the section of workers' compensation law did in fact infringe Section 15. This was the historic trade-off. However, they found under Section 1, remember that Section 1 I was talking about? It was justified. It's interesting because that became moot with the Piercy v. General Bakeries case. In Medwin, the court found that while injured workers of a Schedule II, this is an interesting one, because in Ontario, unlike many provinces, they have what they call as Schedule I and Schedule II employers. Schedule I employers pay premiums into the workers' compensation system, which goes into a fund. It's normally called the injury fund, but not surprisingly in Ontario, they call it the insurance fund. It's because the insurance industry has convinced the provincial government that workers' compensation is insurance, even though it isn't. But because the one thing the insurance industry forgets is that workers' compensation is a right and not a privilege. By the principles of the historic trade-off, and most importantly, by the Meredith principles. So at any rate, in this case, Schedule I employers pay premiums in, Schedule II don't. Instead, Schedule II just pay a nominal fee, and when you're found to be injured, then the employer pays directly your wages and your health care costs and everything. Normally, to my understanding, Schedule II employers must pay 100% of your pay, meaning if you make $20 an hour, that's what they have to pay you. Schedule I, on the other hand, with workers' compensation benefits, for example, in Ontario, it's 85% of your net income. It used to be 90, but Mike Harris in 1997, when he further revised the Workers' Compensation Act, made it the Workplace Safety Insurance Act, he reduced it to 5%. And this is an important note to remember. I never forgot what he said in the legislature. It is to encourage workers to get back to work. And I'm like, wait a minute, you've also implemented very strong return to work compulsory requirements for injured workers. So why would you say that? It seems to be somewhat contradictory. Really, the real reason was to save employers money, because the Conservatives are 100% employer-backed. At any rate, the interesting point about this with this court case in Medwin was, as I said, Schedule II employers pay the workers, but a Schedule II worker can actually sue another employer. They can't sue their own employer for the work injury. So if the work injury occurred in their workplace and with their equipment and everything, they can't sue the employer. But if it was the result of another employer, another employer's worker, or the equipment, then they can sue. And there was a famous case that made it to the Court of Appeal of Ontario, And in that case, it was a hydro worker who fell from the cherry bucket. They call it a cherry picker, the bucket that the man goes up in to fix the hydro lines. And it was defective machinery. And he was allowed to sue the manufacturer of that equipment because he was a Schedule II worker, or a worker of a Schedule II employer. Unfortunately, workers of a Schedule I employer are barred from suing anyone. The only exception that I know of, is two exceptions, is in motor vehicle accidents. You have that option, that right of action as they call it. And there's a lot of gray area because the board sometimes manipulates workers and they don't realize they have that right. It's not made very clear. There was actually a case about that. The other one is a new one, actually, surprisingly, is a Schedule I worker can sue their employer in situations of workplace harassment. And that case was called Morningstar v. WSIAT, where the WSIAT turned around and said, no, they can't sue. It went to the divisional court, and the divisional court said, yes, you can. Now, be careful because there's conditions. Don't automatically assume anything. And moving on, the next one was CanLII, which was about the ability to reconsider decisions. That wasn't really negatively impactful, I don't think. The next one was this case, which was Heiderkamp, and that was a family law issue, was can the Workers' Compensation Board divert your payments to another place? And it says they can, and it's not discriminatory. In Auger, I talked about this earlier under Section 1, which was that it was an infringement under Section 7. However, it was justified under Section 1 because Native workers should be allowed entitlement to workers' compensation just like anybody else. In this case, in Pachacek v. Saskatchewan, the court found that an action lawsuit against an employer government right was barred. And that was another case that further confirmed that, as I talked earlier about the reference v. Nova Scotia, or Newfoundland, sorry. So that's two cases that said that. So trying to break free of that historic trade-off is hard. And I think the reason why is because the courts don't understand that there was a huge historical shift in 1990, at least in Ontario, and I'm sure maybe a couple of years later in other provinces, where the governments moved away from the historic trade-off. And I argue, like I said before, if a worker doesn't have a right to compensation because they're forced back to work, then the employer shouldn't be given the right to immunity. In Horn v. Canada, the court found that the federal workers, now this is another interesting one I was talking about, remember when I was talking about federal workers? And they too, it was not an infringement of Section 15 of the Charter to sue their employers. In referencing the historic trade-off, as I note. I've left these cases up, and as you can see, I've done my best to correctly quote them. Normally, you can find them in CanLII, you can find them in CanLII, C-A-N-L-I-I. That's a free database of court cases in Canada. We're lucky that way because it is accessible and it's free. They also have what's called as CanLII docs, where lawyers, scholars will comment on a case. Unfortunately, it's not as good as the paid services like Quick Law or Westlaw. They offer considerably more information about the cases and more cases. There's going to be cases where I reference and I'll say, oh, they applied to the Supreme Court of Canada but was denied leave. But you go to look for it and you can't find that decision because it wasn't included in CanLII. You can find it in the other paid ones. Unfortunately, these paid legal service databases can be quite expensive. I used to have one myself and it was about $200 a month. Moving on to more case law. In British Columbia, as you can see, these cases cover right across the country from the east to the west. In Isaac v. British Columbia Workers' Compensation, the court found that a Native man who was wrongly denied workers' compensation simply because he worked for a Native man was an infringement under Section 15 of the Charter. I made a mistake in the Alberta one. I thought that one was this one. That one was just slightly different. in Nova Scotia v. Martin. This is a very big case. The Supreme Court not only recognized chronic pain, but the Supreme Court in their decision also recognized the stereotypes of injured workers and the stereotypes of people with disabilities. This is important, and you should, whenever you're making comments or legal arguments before the board or tribunal in your cases, reference that. And when I say reference it, don't just say, this. Actually say, I would like to bring your attention to Nova Scotia v. Martin at paragraph 23, where the Supreme Court recognized the historic stereotype of injured workers faking, or the historic stereotype of disadvantage of people with disabilities, which I might add, as you know, are injured workers. Something to that effect, and it should help you get your point across to the decision maker. It's very important, too, when you're dealing with decision makers, not to attack the decision maker. I know it's hard, it's personal, and it's difficult. As a self-represented person, it is almost impossible to represent yourself because of emotional issues, right? I find there isn't a person I haven't talked to yet that in dealing with their own case, it's very difficult. They have to take breaks. It takes them forever to deal with stuff. And personally, I find it more I'm more aware of it now than I ever was before, because I represent other injured workers, and I don't have as much difficulty in reviewing their file as I do my own personal file. Because in reviewing their file, I'm like, oh man, I feel bad for them. They could have done this, or that they were screwed out of something by the board. But in my own file, I get really upset with myself. Why didn't I do this? Why didn't I do that? That's why often when people say, oh, Paul, you're so smart. Oh, Paul, you know this, you know that. And I'll go, yeah, if I was so goddamn smart, I wouldn't have worked for that employer knowing how dangerous it was. I wouldn't have trusted the workers' compensation system to take care of me. So I'm not that smart. Moving on to the cases in Bowman v. Nova Scotia. This was another case that sort of made its way to the Supreme Court, like my own case in the civil issues. It's interesting when they go all the way through. When they just stay at a certain level, in my opinion, it hasn't really tested the issue. I like to see cases that make it to the Supreme Court of Canada, like in Martin. That way it's confirmed and it's strong. Now, another thing to note about the Supreme Court, they do on occasion reverse their position on an issue. A good one is Carter v. Canada. Prior to Carter, they had dismissed the argument that assisted suicide was an infringement of the Charter. Then for some reason in Carter, they said no. So you got to be careful, because the court can occasionally flip-flop, but they don't just do it without reason. They always have to give reasons, and boy, I'll tell you, they do give extensive reasons. For example, the Vaviloff decision is something like 150 or 200 pages long. That was a huge decision for injured workers in dealing with the issue of judicial review. Judicial review is the step after dealing with a tribunal. So, at any rate, in Bowman v. Nova Scotia, the court found that when the workers' compensation law was amended, preventing the suspension of widow benefits due to remarriage, it only applied to those remarried after April 17, 1985, was an infringement of Section 15 of the Charter. The decision was reversed on appeal on the grounds the provision didn't offend, the Charter. Now, this case is interesting for several reasons. One, it shows you the flow. You can win at the lower level, but always, always, always the board or tribunal will always appeal. Rarely do they not appeal. And this really concerns me as a Canadian, because it's like you're using monies destined for a real purpose just to waste courts' resources and to fight people for no good reason. You know what I mean? Mind you, it's ironically because that's how they label me as a fighter. When my arguments, as far as I know, are fair and reasonable and logical. Theirs are not. They're just like when they talk about the historic trade-off or the transfer to the federal government, I have no doubt the workers' compensation boards will say, they won't say that, they won't make a legal argument and saying, it should be provincial because the provincial system is better able to handle this case or whatever the reasons. They'll just say, well, it should stay the way it is because that's the way it's always been. And to that argument, I give a very famous quote. They'll also say that, and then they might also argue that there's that. But then there's another argument they'll bring out, which is economic cost. Whenever you hear economic cost, and the boards and tribunals always do this in courts, like as if to elicit sympathy from the court to say, well, you know, it's going to cost money. And that there's a famous case you need to be aware of. Very, well, should be very famous, but it isn't. And that's called Stewart v. Somerset, or Somerset v. Stewart. Sorry, I get it mixed up. And in that case, it was Justice Mansfield, Chief Justice Mansfield of the English court. And it was back in the 1700s, and it was the case that decided slavery in England. Prior to this case, slavery was not legal in England, but it wasn't illegal, which is interesting because in its colonies, it was legal. So what happened is slave masters would bring their slaves to England all the time, and there was thousands of slaves in England at the time. And this one slave, his friends who, said, hey, you don't have to be a slave. So then they brought what they call as an application for habeas corpus. It's basically Latin for the right to be interned or imprisoned should be challenged. And you'll hear it in a lot of criminal proceedings. And in that case, one of the arguments that was made was, one is it's always been this way by the slave owners, and two, the whole British Empire, and there'll be economic chaos and a crash. And the reply to the judge to all that was, though the heavens may fall, justice shall be done. Meaning a judge cannot look at what might happen if they make a decision. They can only focus on the evidence, the facts, and the law. Sadly, in my own personal experience, the judges do the wrong thing. They look at what would happen if they make their decision. There was one case where a judge actually said to me, if I do this for you, I will open the floodgates for other injured workers. And I'm like, are you kidding me? You can't do that in thinking that way with your decision. Again, that comment, that decision was upheld by the Court of Appeal, and they didn't seem to care. And I think a lot of this, too, is for the two factors. Is one, you're an injured worker. Two, you're self-represented. These are huge stigmas within the court system. So, and the other issue that I wanted to talk about with this case was the fact that what really infuriated me as a Canadian and as a human being was the fact that it involved widows. Is that they said basically, yeah, we know you're a widow, but we just don't care. And to the board, and the truth is, the only thing they care about is money. And I recall, I believe it was this case where they actually did make the argument of what it would cost. It would cost $10 million and blah, 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 blah. And that's all they cared about, the board. It was really troubling. And the Court of Appeal said, well, we're very sympathetic to your cause. No, you're not. If you don't do the right thing, you're not sympathetic, in my opinion. I get really angry when I hear judges comment like that because they really don't care about doing the right thing in this situation. I don't agree with this. The big issue with this is when the board or legislature found there was a wrong, and they went, okay, we'll fix it, but basically we were wrong, but from now on we promise to be good boys and girls. And they set a date, which was April 17th, in this case, 1985. That I don't agree with because it literally creates classes of Canadians, those before April 1795 and those not. And to me, that's a stereotype or a failing within Section 15 and Section 7. But unfortunately, the judges aren't interested in hearing such arguments. They approve of such categories, whereas with I do not. Another example of this case was in Ontario with the PTSD for first responders. Prior to this date, you didn't get it. After, you got it. Same with non-first responder regular workers. They, a year or two later, a few years later, same thing again. How is it that if I have this condition or injury, or I have this entitlement, I get it just because of today, whereas with you don't get it because of yesterday? To me, that doesn't make any logical or legal or even constitutional sense. But this is how government works, and this is how the courts support them. And to me, it's very disturbing because they're not looking at the impact of the individuals. This is some more cases. As you can see, and again, you can see that it's west and east, it's right across the country. In Burnett, the court found that's the section of the workers' compensation legislation to terminate workers' compensation benefits because of her age as a widow infringed Section 15 of the Charter. Not surprisingly, again, on appeal, the Court of Appeal disagreed. This is another thing too. So when you're dealing with lower court judges and you're like, what the hell? Like, why are they like this? It's because they're realizing every time they do the right thing, they're overturned on appeal at the Court of Appeal or the Supreme Court of Canada. And this is an interesting case because it deals with the age factor. This scares me, and there's other decisions, I think, that I haven't covered yet that deal with the age argument. And that should be a concern for injured workers. Yeah, it is. Actually, it's later down. It's Lerond. At any rate, the next one is Newfoundland case where an injured worker received compensation out of an appeal fund, a special fund. What happened was he was insured for his accident, like say car insurance or something. It was a vehicle accident. He claimed workers' compensation benefits fine, but then the insurance company went bankrupt, and then he was paid out of the special fund. The Workers' Compensation Board sued him and said that he was to reimburse them for everything. And initially the court again found that it was a Section 15 breach, but again on appeal they said no, it wasn't. This is the case that I was concerned about, Lerond in New Brunswick, and the court found that the section of workers' compensation law that commits age discrimination because it suspends workers' benefits beyond age 65 is not an infringement of the Charter. What concerned me about this was the judge's comments in reaching their decision. They said that, it's not right that they have to do this, that it's always been this way, but it hasn't. Because according to the Meredith principles, all the compensation systems based on you get paid for as long as the disability lasts. Whereas with suspending the benefits at age 65 breaches this principle. More importantly, the judge wasn't aware that the laws were changed only recently, and close to 100 years injured workers used to get paid that way. They were only trying to right a wrong. So this is another problem. This is that stigma that's within the judges within our courts towards injured workers, that workers' compensation is a privilege and not a right. Well, they say it is in their actions, and that's what they say. Like when I talk about, when somebody says you hate him or your hatred is legally defined by the actions of an individual or organization. It's your conduct depicts this. In Vail v. Prince Edward Island, the court found that the injured worker were paid for percentages. This is an interesting one because this was a transitional issue between being paid benefits for life as opposed to being paid a percentage based on disability. And they found it wasn't an infringement because that was a transition, one of the transitions from being paid benefits to life or being paid benefits for a period of time. And I think I would rather being paid benefits for life than getting what they call as a non-economic loss award, because these non-economic loss awards are literally a slap in the face or an insult to injury. Pardon the pun, but it's the truth. I mean, they're saying that if you're 100% disabled, your whole body for the rest of your life is worth like $40,000. That's it. And when you think about it mathematically, that's ridiculous. Now they'll say, well, it's not based on income. No, it isn't. But they're saying that all your pain and suffering, all your difficulties you have to deal with this disability is worth $45,000. Clearly, it's a financial decision to set it at $45,000. In Magna v. Nova Scotia, the court found that the section of workers' compensation legislation to deny workers' compensation because a widow no longer was living with the deceased person. This was another interesting one about widow. Prior to death did not infringe Section 15 of the Charter. So in other words, they were together, common law, then they separated. and she claimed it was an infringement of Section 15, probably under the status of family status, and it was denied. Murray Goodwin was another interesting case because his case, I researched his case when I was bringing my civil claim. And in New Brunswick, unlike Ontario, they recognized an injured worker can sue the Workers' Compensation Board. Ontario says you can't. In fact, I can even cite my own case where Justice Price, His Honor, said that the tribunal lacks the legal capacity to be sued, as does the board. Yet, ironically, when he was quoting it, he was quoting Section 1791 of the Act, which only provides the staff immunity. Moreover, subsection 3 and 4 of Section 179 clearly says the board and tribunal are liable. So what do you do when the judge is wrong? Well, you appeal it to the Court of Appeal, and they agreed with the judge. Which really begs the question, why would they agree with a judge who committed a blatant error of law? I don't know, I leave that to you. At any rate, in this case, Murray was granted the right to sue the employer, or to sue the board. And he lost because he didn't prove the points of the abuse of public office, is what it was called. And he tried to bring a Section 15 charter claim, and the court found that it wasn't justified, the Section 15 argument he made. Another part of the Charter of Rights and Freedoms is the official languages and minority language education rights. The official language section basically says individuals have a right to interpreter and right to the language issue. The minority language is basically if you're a Canadian and you're English, say Ontario, whatever, and you move to Quebec, your children have a right to have education taught to them in English, and vice versa. If you're French and you go to Ontario or Manitoba, that's basically that. So it's not really relevant to injured workers. Where probably one of the most powerful sections, including, I would compare it to Section 52, is Section 24. And this is how you enforce your rights as a Canadian. And that is Section 24. Now, most of us are familiar with Section 24.2, which is the second paragraph, where in a criminal proceedings, the court concludes the evidence was obtained in a matter that was basically wrong. They can exclude that evidence and, if necessary, stay or dismiss the case. The one we don't often hear about is 24, the first paragraph, which is anyone whose rights or freedoms as guaranteed by this charter, meaning any section of the charter, have been infringed or denied, may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. So you notice the word jurisdiction, to obtain such remedy. Remedy meaning whatever, anything. It could be, in your case, for administrative. And there's another section. First, I want to talk about court of competent jurisdiction. The Supreme Court of Canada in Martin made clear an administrative board and tribunal is considered a court of competent jurisdiction so long as the legislature hasn't ousted their authority in a law. I believe it was Alberta. The Alberta government said no, they can't. And I think BC as well, I'm not sure. You have to check in your home province. The other thing is such remedy. As I was just saying, such remedy can be anything. So specifically, if you found that a section of law infringes the rights and you're right in it, then while the board or tribunal cannot constitutionally invalidate the law, they can ignore it in your case. So you would ask them to do that. Another option is you can ask for damage awards, meaning monies, if a specific infringement occurred. But you can't make an argument for benefits to be claimed, meaning you can't say you're claiming charter damages specifically. They're saying, look, you're just saying it's benefits, right? But if you won your claim for benefits, and as a result of this infringement, your rights were violated, then you can say, well, in addition to my benefits, I want actual cash damage award. Because to say that giving me benefits is like any other injured worker, but not, you know what I mean? It acts in a punitive way too, because then the board or tribunal, whoever did it, should be punished. And the only way, sadly, is monies. Another fact you could try and do, which they do often, is the Human Rights Tribunal does harass, is if you want them to undergo training or not to do something again. You know, so like say maybe with chronic pain, you say that they have to take sensitivity courses and to recognize in policy that chronic pain or pain is a disability, So your remedy can be anything, but it has to be reasonable, it has to be fair, you can't be ridiculous. And another important point is don't attack the individuals. Whenever you list them as the person who did something fine, but don't say they're to go to jail or they're to do this or they're to do that. It's pointless. Deal just with the board or tribunal. This is why the majority of cases in the courts with injured workers lose, because they attack the individual staff when they should be attacking the board or the tribunal. And I say that because the board and tribunal are, in effect, they are employers and responsible for the conduct of their staff. So if they say, well, we didn't do that, you reply with, you hire them, you train them, you supervise them, and you discipline them, and when necessary, you terminate them. So you have complete control over them, so as such, you are completely responsible for them. The legal term for that is called vicarious liability. Unfortunately, like I said earlier, the courts didn't recognize that argument with me in my arguments with my case. I also want to talk about Section 32. This is a section that kind of disturbs me in a way, because what it says is it only applies to the Parliament of Canada, Yukon, and Northwest Territories, and I'm assuming none of it as well. It also applies to the legislature and government matters. So anything flowing from them, meaning the Workers' Compensation Board, cities, city officers, stuff like that, all that, anything to do with government, it applies, the charter applies. What really bothers me is Section 33, and that is that Parliament or legislature can make a law to exempt the charter or the law from Sections 2 and 7 to 15. So in other words, Section 7 says you have a right to life. However, the legislature or Parliament can pass a law saying you don't. So do we have an absolute right to life or not? Canadian values are you do. That's why we don't have the death penalty. But in reading our legislation, we don't. So that's another issue. And a big, big issue for me is that the charter does not apply to private businesses and individuals when I think it should. The reason why I do is, for example, democratic rights. You could be a member of the NDP and you work for an employer and they find out and they could fire you just because of that. I mean, yeah, you could sue them on wrongful termination, all that other stuff. But you have very little rights as an individual in that sense. Another example with election and democracy is if you have a rental unit and you have a window and someone will put in the window an election sign, you know, vote for NDP or vote for Liberal or whatever, and your landlord can ban you from doing that and punish you. That I disagree with again. And that's why, in those two quick examples, why the charter should apply. More importantly, your right to life argument. Maybe if we did have the charter applying to businesses when workers are killed in the workplace, if the government chooses not to properly act in the criminal process like the West Ray Mine Act, and I'm going to talk about that in another video of the employers that have been convicted or not and how it works, because I have 2 books on the subject, very heavy books. I can't find them right now. But at any rate, and they're written by legal scholars. And I'm going to talk about that subject and my concerns with it. Maybe if the charter did apply to businesses that and the worker was killed, that they could bring a charter argument, you know, for the negligence caused by an employer, because one of my big issues is that the way the current workers' compensation system is right now is that, in my opinion, with rebates, with lax enforcement, it has become a system that workers are getting hurt every day and employers are not paying the price. They're not paying any price. In fact, they're being rewarded for it. And that's a failing of our government. And one of the main reasons why there was such a shift and change was it occurred in 1990 in Canada, or around the 90s, was something called neoliberalism, or is what we commonly know as globalization, or global capitalism, or globalization. But neoliberalism is an economic policy, and I'm going to talk about this too in a later video, and how it's directly impacted injured workers and the, in my opinion, illegal, unconstitutional, immoral, and unethical austerity measures imposed on injured workers. And I say this because the legislatures, when arguing for cuts to workers' compensation, will often say it's tax savings, it's better for taxpayers. And what they're doing is they're putting forth a fraudulent claim, because as we all know, workers' compensation is solely funded by employers, or it should be. And if it isn't, it should be, and it must be. And for that reason, why should workers pay? And like I say to employers, you know, you're lucky right now because you don't get sued. And workers only get 85% of their benefits in Ontario. They get a pretty good deal right now. But as they say, eventually the bubble bursts, eventually the elastic band breaks. And that's what's going to happen with workers' compensation. Then we may end up in a very pre-workers' compensation state, which is something I don't want. And most injured workers shouldn't want. Because you want that you get hurt today, tomorrow you get coverage. You're protected, you're cared for. That's what we want. But in the system being so badly corrupted by employer bribing lobbyists, now we're at a point where we're going to have to fight to get rid of the whole system. And in doing so, we're going to put injured workers at risk. And more importantly, we're going to put employers at risk. Imagine an employer being sued for one work injury. Millions it could cost them. And several, especially dangerous, like where I worked at Canadian Tire, they knowingly endangered workers. They do it today. Many, many, many. And they don't care. But in that situation, instead of one worker suing them, there's going to be hundreds, thousands suing them. They'll be bankrupt within a week. Is this what they want? Seemingly, this is what they want. They want to bring about their own demise. Sorry about my rant. So at any rate, how can you enforce your rights? What can you do? In Ontario, if you wish to claim a remedy under Section 24(1) of the Charter, you do so by bringing an application or a notice of constitutional question. And how you would do it is, so you'd say, well, what do you mean? Like, what am I claiming? Now, you know the remedy is either monies, conduct, or change. You know what I mean? So you have these options. But what can you bring it for? What action? And that is you can bring it for an unconstitutional section of law, which could be the Workers' Compensation Act law, or policies or procedures. Also, decisions of the board and tribunal. You can also bring it for an act of omission, meaning that they were supposed to do something but didn't do it. Like, for example, giving you proper health care. Oftentimes, I find a very common one in this situation or category of omission is the boards will say we don't pay for maintenance for health care. What the hell's maintenance? I've never heard that word before. To me, health care is health care. If your doctor, if your treating person, your health professional says you need this to manage or whatever you want to call it, you need this health care, then you need this health care. But the reason why they're doing it is, think about it. Physiotherapy costs a lot of money. And this gets me into another video, unfortunately, which is on the opiate epidemic. You know, and what angers me about this is the fact that, in my opinion, workers' compensation systems in Canada and North America abused the opiate drugs, because they would say, we don't have to give you physio anymore because we can pump you full of opiates. Your pain is gone, so you can work now. We're all happy. The only problem is many workers' compensation boards turned hard-working Canadian workers and others into drug addicts. And sadly, when these drug addicts commit crimes, they're thrown in jail. The workers' compensation system is free of any wrongdoing. And this is what I argued before a law firm that was seeking out people for a class action for opiates. They were going after, I think it was a marketing company or something, and it was Goldplat Partners that was doing it. And I had said to the lawyer, you know, your sweet spot is actually the workers' compensation boards for several reasons. One, they not only encouraged the use of opiate medications, they paid for it, but also, too, more importantly, unlike the drug company that went bankrupt in the States, they can't go bankrupt because they're backed by the government. So you have a really golden opportunity. But this gets to a bigger point in legal discussions about the workers' compensation system. Why are these law firms taking on big, huge corporations, drug manufacturers? Drug manufacturers in the States are considered massive monsters that are unbeatable, and they're taking them on. But yet, in Canada and in the US, they stay well away from the workers' compensation system, the boards. And I think it's because they know it's unwinnable. Because they know when they go to court, they won't win. And they'll lose everything that they've done to that point. So this is the end of part 3. Sorry, I said don't forget to check out part 2. I screwed it up again. And you'll probably notice some typos in that. I'm not perfect. I make many mistakes. And like I was saying, I broke this down into small, short videos. Unfortunately, they're not timed perfectly. They vary between 30 minutes and 45 minutes. And I do apologize for that because sometimes I get into a bit of a rant on each slide. And I hope you find it a bit entertaining. So hopefully I'll see you in not part 2, but part 3. Thank you.